Have you ever wondered how these giant global companies, the ones that operate all over the world, settle these massive, high-stakes disputes without a huge, messy, public court battle? Well, today, we're going to unlock that powerful, private world of international arbitration.
Really think about that for a second. When two multinational corporations have a billion-dollar disagreement, how do they actually solve it? It turns out the answer is this powerful and very private system that was basically designed for our modern, globalized world.
So here's our game plan for this explainer. We're going to start with the basics. What exactly is arbitration? Then we'll get into its biggest advantages, and we'll take a closer look at privacy and cost. After that, we'll uncover its secret weapon, enforceability, and we'll wrap up by looking at some really interesting hybrid approaches.
All right, first up, let's get right to the heart of it. What are we actually talking about when we use the word arbitration?
This slide takes us straight to the source material. And as you can see, the core idea is that arbitration is a consensual method. That means both parties have to agree to submit their conflict to a neutral third party, a tribunal.
And that word consensual is absolutely key. Both sides have to agree to do this, and usually that happens in a contract they signed long before any problems ever came up. So this neutral tribunal, they act like a private judge, and their final binding decision isn't called a verdict, it's called an award.
So who are these decision makers? Well, for simpler cases, it might just be a single arbitrator. But for the really complex, international stuff, it's usually a three-person tribunal. And often, these are experts who come from totally different legal backgrounds, which can be super helpful. Okay, so we've got the what and the who down. But the really big question is why? Why on earth would two massive companies choose this private system instead of just going to a public court?
Well, this slide pretty much lays out the highlights. First off, you get a ton of flexibility. The parties actually get to choose their own judges, the tribunal. The whole thing is confidential, which is huge. It's often way less complex than a traditional lawsuit. And, as we'll see, the final decision is enforceable all over the world.
This quote from the source material really nails it. Just imagine that. Instead of being locked into these rigid, ancient court rules, the two companies in the dispute actually get to shape the process themselves. For a global business, that level of control is an absolute game changer.
Okay, now let's zoom in a little bit and take a closer look at three of the most important aspects our source highlights: privacy, time, and, of course, cost. The difference here is like night and day. Think about two huge tech companies fighting over the source code for their next billion-dollar product. If they go to a public court, that code, their biggest, most valuable secret, could become public record. Any competitor could just go look it up. Arbitration keeps all of that behind closed doors. That's why they literally agree to renounce the right to public justice. Now you're probably thinking, a private system with hand-picked experts, that sounds really, really expensive. So let's just ask the question everybody wants to know the answer to. And the answer is, well, it depends. Yes, you do have to pay the arbitrators, and that can be pricey up front. But a well-managed arbitration can be so much faster and more efficient than a court battle that drags on for years with endless appeals. So, in the long run, it can absolutely save a ton of money. But you know what? None of this, not the privacy, not the flexibility, not even the potential savings, none of it would matter without one absolutely critical component. This is the secret sauce that gives the entire system its real power. Because look, winning a case is one thing, but actually collecting the money is something else entirely. Imagine a French company wins an arbitration award against an American one. How do they actually enforce that decision across an ocean? For the award to be useful at all, it has to have real legal teeth, just like a local court's judgment. And the solution to this huge global problem was basically solidified in one single pivotal year. That year gave us the New York Convention. And this treaty, it is a masterpiece of international law. Over 160 countries have signed it, and they all agree to one simple, incredibly powerful promise. We will recognize and enforce arbitration awards from other member countries as if they came from our very own courts.
And this quote from our source, it just says it all perfectly. The New York Convention is, without a doubt, the backbone that holds this entire system of international arbitration together.
And because this whole field is built on this idea of flexibility, it can even be combined with other kinds of dispute resolution to create some really innovative, creative solutions.
So take something called med-arb. The parties first try to negotiate a settlement themselves with the help of a neutral mediator.
But if they can't agree, that same person takes off their mediator hat, puts on their arbitrator hat, and makes a final binding decision. This creates a really powerful incentive for everyone to just settle the case themselves.
Or you can just flip the script with something called Arb-Med. Think of it this way. The formal arbitration clock is already running, but you hit the pause button to give mediation a shot. If you manage to settle, fantastic. If not, you just unpause the clock and continue the arbitration right where you left off. It's all about finding the most efficient way to get to a solution.
So, if you're going to remember just a few things from all of this, what should they be? First, arbitration is consensual. Both sides have to agree to it. Second, it's private, which is crucial for protecting sensitive business info. Third, it's flexible, so you can customize the procedures. And finally, and maybe most importantly, thanks to the New York Convention, its decisions are globally enforceable.
And all of this leaves us with one last big thought to chew on. In a world where business moves faster and crosses more borders than ever before, is it possible that this private, flexible, and incredibly powerful system of justice could actually become the new global standard for how we solve our biggest and most complex disputes? It's definitely something to think about. Thanks for tuning in.